All right, good afternoon, everyone, and welcome to today's webinar, Final HIPAA Rule to Support Reproductive Healthcare Privacy, Impacts for Public Health, brought to you by the Network for Public Health Law and the American Society of Law, Medicine, and Ethics. Just a reminder that you will be receiving a copy of all of the slides and a recording of the webinar in about a week. And you will also be receiving an email from ASLME regarding CLE credits if you are applying for those. With that, I'll pass off to Susan Florent, who will be our moderator for today's webinar. So Susan, over to you.
Thank you, Daniel. Hi, everyone, and welcome to our webinar today. On April 22nd, the Biden-Harris administration, through the Office of Civil Rights at the Department of Health and Human Services, issued a new HIPAA Final Rule. This rule seeks to strengthen privacy protections under HIPAA for protected health information potentially related to reproductive health care. Today, we will discuss key provisions, potential challenges, and what this means for public health. My name is Susan Florent, and I'm a staff attorney with the network's Mid-States region. I will be moderating today's webinar. Please note that this presentation is for informational purposes only. For legal advice, please consult your legal counsel. Next slide. I'm joined today by three of my colleagues. Stephen Murphy is the acting director of the network's Mid-States region. Prior to joining the network, he was a privacy attorney for the Chicago Department of Public Health. Chuck Curran is a deputy director with the network's Mid-States region with over 20 years of experience developing solutions to policy and regulatory challenges in the digital space. At the network, his work focuses on data privacy and the intergovernmental exchange of health information. Joanna Suter is a senior attorney for reproductive health at the network. She previously served as a deputy attorney general for the state of Delaware, where she represented the Division of Public Health and led the health law unit. After the three speakers present, we will have a bit of time for discussion and questions from attendees. Please use the Q&A function at the bottom of your Zoom window to submit questions. And with that, Joanna, I'll turn it over to you.
Thank you so much, Susan. First, I want to do a shameless plug for our Fall Summit, which is happening in September. The theme this year is taking action on maternal and reproductive health. So if today's topic interests you, please check out that link on our website and sign up for our Fall Summit. We would love to see you there and hear about what you're doing with your work. Next slide, please, Daniel. So I'm going to present today on how did we get to this new final rule, give a bit of the background of where we are with reproductive health in this country, the different stances that states have taken that have led to this federal action. Next slide, Daniel. Thank you. So most of us know about the case of Roe versus Wade, which was decided in 1972 and was the law for almost 50 years in this country. In that case, SCOTUS held that there was an implicit right to privacy found in the Due Process Clause of the 14th Amendment. This right was not absolute, but balanced against the government interest in protecting the health of pregnant people and protecting the potentiality of human life. Next slide, Daniel. And the counter to Roe versus Wade is Dobbs v. Jackson Women's Health Organization, which was decided almost 2 years ago now in June 2022. The facts of that case are that Mississippi passed a 15-week abortion ban with exceptions for medical emergency and severe fetal abnormality in clear violation of Roe. And as a reminder, Mississippi did pass this law on purpose to challenge Roe versus Wade and attempts to have it overruled. The Supreme Court held in that case the federal constitution does not confer a right to abortion, overturning Roe, and return the issue of abortion to the states. So what have we seen since June 2022? Daniel, next slide. This is the map as of last week. 14 states have banned abortion, and 8 additional states have gestational age limits on abortion. In practicality, what does this mean for patients and providers? Next slide. It means a lot of confusion, honestly, and we see this in the news almost every single day. Not only is there confusion about what providers can do, there's confusion about what providers must share or should share when that information is requested. This is especially concerning when the request is from a state where these healthcare services may be illegal. Next slide. So this map is from the Center for Public Health Law Research at Temple University using their Law Atlas system. And this is a map of highlighted states with laws that prohibit the disclosure of medical records for reproductive health purposes. This was last updated until June 2023. So there might be some updates past this. And if you're in a state where you know a law has been passed prohibiting this disclosure and it's not on this map, let us know. And we'll reach out to our friends at Temple and let them know as well. As an example, one of these laws, Maryland House Bill 812, prohibits the health information exchange or health network from loading mifepristone data. Mifepristone is the one of the medications for medication or diagnosis, procedure, prescription care to treat care. The only allowances for the sharing is for adjudication of insurance claims and to a provider with written consent of the patient. I think it says my audio is breaking up. Apologize about that. Hopefully it gets a little bit better. If you want to know about these state laws, Stephen presented on them in a webinar in December that we did, and we have a lot of resources on these kinds of state laws, especially on shield laws that protect providers. Shield laws also include laws that protect courts from issuing foreign subpoenas and taking other actions. But state laws vary widely because they are state laws, and they are not supposed to be, universal attempts to fix a system that may be confusing to certain populations and providers. Next slide, please. So the Biden-Harris administration has issued a set of priorities where they are, the Biden administration has issued some priorities on reproductive rights, so they can take steps that the federal government can take, which are more limited than what the states can take, especially in the realm of public health law. I will turn my camera off and see if that helps. Next slide, please. These are the Biden priorities from the White House Task Force on Reproductive Health Care. Oh, thanks. To safeguard privacy and sensitive health information. The first priority is taking action against illegal use and sharing of sensitive health information. These will be enforcement actions by the Federal Trade Commission. Helping consumers protect their personal data. This is the Federal Communications Coalition issuing guidance, protecting students' health information. This is Department of Ed guidance on FERPA, and safeguarding patients' electronic health information, and this was HHS guidance. And the topic that we are going to discuss today, which is strengthening reproductive health privacy under HIPAA. The notice of proposed rulemaking for the new HIPAA rule was published on April 17th, 2023. The network submitted comments to those proposed rules, and if you're interested in reading those, they are available on our website. And the final rule was published on April 26th, 2024. And with that, I'm going to turn it over to my esteemed colleague, Stephen Murphy, to give an overview of the final rule. Thank you.
Thanks so much, Joanna. And your sound actually sounded great once you turned your camera off. So thank you for that. Thanks for the great introduction, Susan. And thanks everybody for joining us today. So I'm going to go through the kind of big highlights of what's in the final rule. And I just want to make a note that if you do have questions, please put them into the Q&A and we will answer those as we go along and also during our Q&A. That would be super helpful. It'll help us keep track of the Q&A as well. But so let's jump in. Can you go to the next slide, please, Daniel? So, okay, there's a few, excuse me, big changes here that we want to talk about. Two big ones, really, and then some other changes that are of note as well. So the first big one is this general prohibition on the use and disclosure of protected health information for prosecutions and investigations of individuals merely for seeking, obtaining, providing, or facilitating reproductive health care. And we'll talk about the different bells and whistles that are included in there in just a moment. The other big one is this attestation requirement that applies to certain uses and disclosure that are already permitted by the rule, but now will require this additional attestation to say that the information is not going to be used for a prohibited purpose. In addition, we have some new definitions around the person and public health and reproductive health care. We'll talk about some clarifications that HHS has made as well around certain permitted uses and disclosures that relate to victims of abuse, neglect, and domestic violence. And then I just want to emphasize here that throughout the new rule, HHS has made these purpose-based limitations, and they've emphasized that repeatedly in the preamble to the final rule, that they're not creating a new category of protected health information that would, for example, have to be segregated from other types of protected health information. They're focusing here on the purpose, on what can be done with protected health information in certain instances. Next slide, please. So let's start with this general prohibition. So there's a section within HIPAA at section 502A5, which currently includes two big prohibitions. There's a prohibition on using genetic information for underwriting purposes, and there's also a prohibition on the sale of protected health information generally. So now HIPAA is adding this third prohibition. This was in the notice of proposed rulemaking and has made it into the final rule. This general prohibition is that covered entities and business associates may not use or disclose protected health information to conduct a criminal, civil, or administrative investigation into a person merely for the act of seeking, obtaining, providing, or facilitating reproductive health care, or to impose liability on somebody, whether it be civil, criminal, or administrative, again, for the mere act of seeking, obtaining, or providing, or facilitating reproductive health care. And similarly, a covered entity or business associate may not use or disclose protected health information for the purpose of identifying somebody in order to proceed with an investigation or a prosecution in the same guise. Let's go to the next slide, because there's some clarifications on this, on how it applies, when it applies, and then there's a presumption that we need to talk about as well. So in terms of applicability, so this general prohibition on use and disclosure of protected health information for investigations and prosecutions of individuals merely for the act of seeking or obtaining or facilitating or providing reproductive health care applies only in connection with a person who is seeking, providing, or facilitating or obtaining reproductive health care, and the covered entity or business associate must have reasonably determined one of the following, at least: that the reproductive health care is lawful where it was provided and under the circumstances in which it was provided, that the reproductive health care is protected by federal law, including the Constitution. And as we know, although the Supreme Court has stated that abortion is no longer a constitutional right, despite 50 years of jurisprudence to the contrary, contraception still is protected by the Constitution. And so that's another instance. And then there's this presumption that we need to talk about as well. But so those are the circumstances. It has to be lawfully provided, or I should say, it must be protected by federal law. And let's talk about this presumption if we go to the next slide. So again, we're still talking about this general prohibition on use and disclosure of protected health information for this repro investigations and prosecutions. But reproductive health care is presumed to be lawful unless covered entity or the business associate has actual knowledge that the reproductive health care was not lawful under the circumstances in which it was provided, or the covered entity or business associate has factual information that is supplied by the requester of the information that creates a substantial factual basis that the reproductive health care was not lawful under the specific circumstances in which it was provided. So that's it around this general prohibition. It's this general prohibition on use and disclosure of protected health information by a covered entity or a business associate, where the information relates to the a person seeking, obtaining, or providing or facilitating reproductive health care, but only applies where the care is lawful or where it's protected by federal law, and the care is presumed to be lawful unless the covered entity has actual knowledge that it's not, or has factual information that's provided by the requester that creates a substantial factual basis to believe that the care is not lawful. And that presumption can be overcome by the requester, but this burden then is on the requester to overcome that burden by providing information that would show under these circumstances, under these terms, that the care was not lawful. Let's go to the next slide, please. So this next piece then is about this attestation requirement. So there are a few provisions that OCR is, or that rather HHS is pointing to here that already permit uses and disclosures. So there are permitted use and disclosures by a covered entity or a business associate for health oversight that already exists in the rule. And that's where you have, for example, an inspector general that's investigating Medicaid fraud, for example. There's permitted uses and disclosures for judicial and administrative proceedings. That might include where you have an attorney who provides a subpoena and a qualified protective order. That's permitted to as a basis to provide protected health information. Law enforcement, there are provisions within the rule as it exists, as it has existed, to allow law enforcement under certain circumstances to obtain protected health information, such as when they have a warrant or where they provide a grand jury subpoena. And then there's also permitted uses and disclosures to coroners and medical examiners for the purpose of determining a cause of death, for example. So those different uses and disclosures have always been permitted, but now the rule is going to require that anybody who is requesting protected health information for one of these purposes under one of these provisions has to provide a valid attestation, and there are requirements around the attestation that it has to be signed and that it has to identify the individual that's requesting the information. It has to identify the subject of the information or the class of individuals who are the subjects of the information. Has to identify who's providing the information, and very importantly, it has to include a sentence that states that the information is not being requested for a purpose that is prohibited under one of these provisions that we just talked about. So it's not prohibited. It's not going to be used for investigations and prosecutions of an individual merely for the act of seeking reproductive health care. Let's go to the next slide, please. Okay, so that's it on the general prohibition that we talked about and also the attestation. Now, there's some clarifications as well in the rule around victims of abuse, neglect, and domestic violence. So the privacy rule already includes a provision that allows a covered entity to refuse to treat somebody as the personal representative of an individual if the covered entity has a reasonable belief that that individual that's purporting to be the personal representative is actually the perpetrator of domestic violence or abuse or neglect. So now the new rule is stating that a covered entity may indeed continue to refuse to treat somebody as a personal representative under those circumstances, but the refusal cannot be based on a reasonable belief that the individual is involved in the provision or the facilitation of reproductive health care. So that's one clarification. And you can think of examples there where perhaps a parent brings an adolescent to for reproductive health care services. The new rule is stating that the covered entity can't refuse to treat the parent as a personal representative because of their views around reproductive health care, basically. And then the second clarification on this victims of abuse, neglect, and domestic violence, the rule already permits uses and disclosures in certain circumstances around victims of abuse, neglect, and domestic violence, but the new rule clarifies that the sole basis of a report of abuse, neglect, or domestic violence that would allow for these disclosures cannot be based solely on the provision or the facilitation of reproductive health care. So basically what HHS is doing here is saying that this provision that already allows for uses and disclosures of protected health information about victims of abuse, neglect, or domestic violence cannot be used as a backdoor for law enforcement to obtain protected health information that's going to be used for law enforcement purposes relating to reproductive health care. Let's go to the next slide, please. Okay, so just last couple of points here. There are some new definitions that are included in the rule as well. There's a definition of the person, which is defined to mean a natural person. And that is clarified to say that that means a person who is born alive. And that is particularly relevant to a provision within the rule that already allows for uses and disclosures to avert a serious and imminent threat to a person or the public. And so here HHS is saying that that provision that allows for uses and disclosures to avert a serious and imminent threat to a person, the person in that situation has to be a natural person. It cannot be, for example, a fetus or an embryo. And HHS actually received some comments that they mentioned in the preamble where folks were concerned that they wouldn't be able to use that provision to avert serious and imminent threat to a fertilized egg. And so HHS is here saying that it has to be a natural person. And then the second clarification that I want to just mention here is a new definition of reproductive health care. Healthcare has always been defined in the rule, and now this additional definition of reproductive health care has been added, which is basically healthcare that affects the health of an individual in all matters relating to a reproductive health system and to its functions and processes. So let's go to the next slide. And with this, I'm going to pass things over to Chuck, and please do continue to enter questions in the Q&A if you do have questions.
Thank you, Stephen. So I'm going to cover the public health specific portions of the new rule. You go to the next slide. But really, the key point to take away from this, from all of this discussion that I'm going to cover, is that while the rule is not only strengthening privacy protections for reproductive health care by limiting the availability of data for civil or criminal enforcement, it's also taking the stance that it's trying to prevent public health reporting and disclosure requirements from being used as a means to circumvent these new requirements. So just keep that general purpose in mind as we go through some of the analysis of the specific definitions for public health as interpreted in the final rule. So in order to make clear this distinction between the prohibited civil or criminal enforcement uses and traditional forms of public health, what the final rule does is unpack the reach of HIPAA's preemption and the limits of the exception to that preemption for state public health surveillance, reporting, and investigation. And the rule starts off by analyzing the scope of the exception to HIPAA preemption for the reporting of disease, injury, birth, or death. And what HHS says is that this type of vital statistics reporting are limited and have been historically distinct from information gathering by the states for civil or criminal enforcement purposes. And HHS concludes that this type of public health reporting has never been meant to use to gather information for enforcement purposes or for imposing liability. And that's not just in the context of reproductive health care, but for any form of health care. So the final rule takes the approach that HHS continues to have authority under HIPAA to interpret the limits of permitted vital statistics reporting, and reporting to a public health authority continues to be permitted when HIPAA's requirements are met. But if there's a non-public health purpose that involves that law enforcement enforcement that Stephen covered, then it's governed by the new final rule requirements. And notably, at least for disease or injury and birth and death, HHS has declined to offer new definitions. It's just resting on its general analysis of the distinction between public health purposes and the enforcement purposes that are covered by the new rule. If I could have the next slide, please. However, in the case of the term public health itself, which obviously ripples through the entirety of the HIPAA statute in terms of and the final rule in terms of reporting and disclosures for public health purposes, HHS has inserted a brand new definition, and here the HHS has focused on a new definition that is centered around the notion of population health activities to prevent disease and to promote the health of populations. In the initial rule, the HHS emphasized the population level aspect of public health, but there were comments asking the question of what about the scenarios in which individual PHI would be needed in order to carry out public health related investigations. And so in response to those comments, the final rule incorporates a new clarifying sentence, which reads that such activities include identifying, monitoring, preventing, or mitigating ongoing or prospective threats to the health or safety of a population, which may involve the collection of protected health information, in other words, relating to individuals. And so that means not just population health, but the spread of communicable disease, quarantine, contact tracing, even if these at times focus on individuals. And once again, as with vital statistics reporting, note that this definition doesn't just apply to reproductive healthcare, it applies to all data related to healthcare activities. But just as with vital statistics reporting, the final rule concludes that these provisions of public health under the final rule do not encompass civil or criminal enforcement purposes. And by implication, the new requirements and protections apply in the context of reproductive health care. Next slide, please. So what does this mean for public health data transfers? Generally, there's a great deal of reassuring commentary in the final rule that the rule is not intended to upend bona fide public health uses of data for reporting or investigations. Once again, emphasizing purposes where a valid and bona fide public health purpose exists. The intention is not to disrupt this. And there's we've included the actual rule commentary. You can go look after the webinar, but they specifically call out surveillance related reporting and how these are not affected. They discuss bilateral agreements between the states and the federal government, and they even make the affirmative point around the reporting from the states to the federal CDC of reproductive health related data, still within the scope of public health under the new rule, and then also a reassuring commentary about mandatory mandatory reporting requirements in the public health sphere. And so, and it said there's a specific call out to the fact that this mandatory reporting is not prevented from compliance by the requirements of the new rule, so long as it is in the public health purpose allowable. Go to the next slide. But certainly, to the extent that the final rule is focused on the purposes of investigation or enforcement against individuals, where public health is involved, just as with the rule in general, there is a specific emphasis that regulated entities responding to requests for data still have a responsibility to assess and reasonably figure out whether or not a public health purpose for the request actually exists, or whether, by contrast, there is a criminal or enforcement purpose that's subject to the new requirements of the rule. So on the one hand, you have language in the commentary in the rule making clear what's outside of the scope, but even in a civil or criminal enforcement context, if a state simply says that there is a public health purpose, there isn't a reasonable approach that says, well, you can simply accept that on face value. And importantly, there's one specific example offered in the commentary. HHS gives the example of a request that for reporting of all PHI of all individuals who receive treatment for uterine bleeding, which comes in under the rubric of a public health purpose to investigate infection control practices by obstetricians and gynecologists. But HHS knows, but if this is occurring in a state where law enforcement has publicly announced its intention to investigate individuals for traveling out of state to seek reproductive health care, then it may not be reasonable for a regulated entity to rely on that stated purpose for the public health request. So in sum, really what is the public health discussion is really about demarcating a somewhat clear line between bona fide public health purposes and the responsibilities of regulated entities to ascertain that in fact remains the case, but also to recognize the possible enforcement purposes that are subject to the new requirements of the rule in connection with reproductive health care. And so I'll come back to our moderator, Susan.
Thank you, Chuck and Stephen and Joanna, for sharing that information, and we'll jump into a discussion. Thank you to those who have submitted questions. We are receiving many questions through the Q&A, and I'm seeing them in the chat as well. We also welcome ideas for future network webinars or resources that would be helpful to the public health community. So please feel free to add any suggestions to the Q&A or email us directly. The emails are available here. But first, to get us started, as is often the case with a new rule, there are ambiguities, unknowns, uncertainties. So I'll invite the panelists to speak to that with regard to the final rule. Are there potential unintended consequences that you're thinking about at this stage?
I can jump in, but I do obviously want to hear from Chuck and Joanna too. But I think with any new rule, I think there's going to be some unforeseen issues. And I think one thing that comes to mind is I think the rule focuses on lawful reproductive health, and the prohibition that I mentioned is around where the care is being provided lawfully. I think that is not always clear. Whether the care is lawful or not, and particularly if you think about the EMTALA context, where there's obligation to stabilize a individual, and that is a topic that's still undecided as to what exactly that means in the reproductive health context and the need for an abortion, for example. So I think that's going to be an issue. Is some uncertainty around what is lawful care and what's not lawful reproductive health care, that I think could lead to some questions. I think another unintended consequences might be around this attestation requirement. And I guess it's really just an ambiguity, but the attestation applies to health oversight, for example, but does not apply to public health. And I think many of the agencies that are represented on the call today, among our viewers, have both a public health function and some health oversight functions. And records custodians and privacy officers receive requests for protected health information, but most often they don't state this is a request for health oversight under 45 CFR 164.512 D or E, or whether it's B for public health. I mean, that there's some need for determining which provision it falls into. So, I think this just kind of complicates the issue, because you don't know whether then an attestation is required or not, based on whether is it public health or is it health oversight. So I think that's another part where there could be some questions. Chuck, any thoughts?
Yeah, and I would just, so much of the rule is focused on distinguishing the scenario in which an entity is receiving a request about care it provided, and where it is assessing a request where it has a record relating to care provided by another entity. And this, is principally the going out of the scenario of someone going out of state. And the HHS, the kind of purpose of the rule is to preserve that the full medical record is intact, and to allow out-of-state medical care to be retained in a provider's record in their home state, but nonetheless for it to be subject to new protection, at least under HIPAA, from disclosure where that care provided in a different state is lawful, either under state law or otherwise under federal law. And so I think really part of what you just said in terms of some of the challenges in figuring out lawfulness is in particular more difficult in the context of and this is where the presumption of lawfulness kicks in with some force is what is a regulated entity with a record relating to out-of-state care supposed to do, and can it and should it rely on that presumption in order to maintain the integrity of the record, but also ensure that the purpose of the final rule to prevent the disclosure of health information that was lawful from happening. So I think as you read the rule, it's critical to distinguish between the in-state care and out-of-state care scenarios.
And I will jump in, but go off camera. I think not so much a technical rule, an intended consequence, but something we really have to be mindful of is, litigation that may come about sooner rather than later. In this case, we see a lot of litigation from states who have abortion bans on the books, or who look to restrict this kind of healthcare under these types of rules. So there could be litigation, there could be quote unquote nationwide injunctions in place in certain jurisdictions. So this rule could apply in some places and not in others. And while we wait for a further answer from that, we're also in an election year. And because this is an administrative rule by the Department of Health and Human Services, a new administration could come in and roll back this rule and put in place a completely different rule. And we have seen that with the Section 1557 anti-discrimination regulations, and also with the Title 10 regulations, especially over the last two administrations. So that is a potential confusing issue that may come up as well. And I'll pass it back to Susan for more questions.
Thanks all. Next, turning to Chuck, I'm wondering if you can speak to how the new final rule requirements might affect recent efforts to improve public health data exchange and interoperability.
Well, there certainly in the rule commentary, there's emphasis on the continued importance of strengthening national data health record exchange and with TEFCA, and certainly a policy purpose to ensure that these records are complete. And also really some reassuring provisions of the commentary about trying to preserve, certainly in the public health context, the reporting, traditional forms of reporting. And so I think that certainly the intention is not to disrupt. What gets interesting is that certainly the department rule applies a purpose-based analysis, and specifically avoids an approach that would require sort of operational reproductive health data segmentation, which would play out in both a clinical and a public health context. And the rule basically chooses not to go down that path. What's interesting, of course, is that there are some states, such as California and Maryland, that have in fact begun to go down the path of a technical implementation of reproductive health data control. So, it remains to be seen how operationally, both for clinical and for public health purposes, that these two different approaches, a purpose-based access versus operational data management approaches, will play out together in terms of all the kinds of cross-jurisdictional data sharing for clinical purposes and clinical purposes and for public health that we're otherwise trying to encourage.
Thank you, Chuck. And
I'll just add,
oh,
Susan, that I think this attestation requirement, there's some talk in the preamble too about like whether the attestation requirement is going to create unnecessary barriers to accessing information, electronic information, and OC, or rather HHS opines that these permitted use and disclosures to which an attestation will now be required have always included some need to verify certain criteria are met. And so they're of the mind that this will not change that, so it won't slow things down. But I think it's a valid concern as to whether it would have any effect on data exchange. And I agree with everything Chuck just said.
related to the attestation, Stephen, that you're just discussing, somebody has asked if HHS has provided a standardized attestation that can be filled in by a requesting party.
It's interesting. Chuck and I were just talking about this just before the webinar started. If memory serves, there is mention in the preamble that HHS is planning to issue a sample attestation. And so we'll see what HHS comes up with.
Another question we've received a few times is whether the new definition of reproductive health care encompasses gender-affirming care.
Well, we have I'll try and answer this. I don't believe that the final rule commentary explicitly addresses that question. You can certainly, if you go back and search through the final rule, look, it's a somewhat broad definition, although modified from the initial rule. If it's in all matters relating to the reproductive system and its functions and processes, certainly has a potential breadth. So I would encourage you to look through the entirety of the commentary and the rule to see to what extent any guidance or commentary has been offered as the preliminary rule has changed to the final rule in response to comments.
Another question that is coming up is about the relationship between states that have varying levels of protection for reproductive health records. I'm wondering if you can speak to the interaction between the final rule here and the protections that some states have established to prevent uses of reproductive health care data for enforcement purposes, which you've spoken to a little. Just wondering if anyone wants to expand on the discussion around states.
Sure, I can jump in, Susan. And actually, we have produced several resources, a couple of fact sheets actually over the last 12 or so months on state efforts to bolster the privacy of reproductive health related health information that have included efforts by states and some localities and some executive orders from different governors around the country that have expressly prohibited the disclosure of information to law enforcement for the purpose of investigating or prosecuting somebody for reproductive health care, with limiting or with varying scope. In some cases, the jurisdictions have prohibited state agencies from cooperating with out-of-state investigators, for example. But some are a little more sweeping. I think California passed a law that prohibits healthcare providers from cooperating with out-of-state investigators, if I'm not mistaken. And this, I think what HIPAA is hopefully doing here is plugging the holes in these variations that we have from one state to the other. And, these are variations from one state to another that actually have taken steps to protect reproductive health. But of course, there's many states that are of particular concern that, are intent on taking adverse action against individuals for seeking or providing care. So, hopefully this will provide a national floor for the sharing of protected health information related to reproductive care. It has its own limitations, of course. HIPAA does not apply to all health information, doesn't apply to the apps on our phones, for example, or to our browser histories. and only applies to covered entities and business associates. So there are many more folks who deal with health information that will not be impacted by the privacy rule itself.
I'll just add that the discussion in the rule acknowledges that that does not encompass all forms of potential investigation related to reproductive health care. And there are processes that don't involve the regulated entities that could involve witnesses. And it also must be emphasized that the rule quite explicitly acknowledges that in states in which there is potentially unlawful health care, the rule acknowledges the potential interest of state enforcement in pursuing that records, and that the rule does not completely preclude that from occurring, but as it relates to regulated entities, it's subject to the requirements of attestation, so the department frequently uses the term of balancing of interests, and in that where care is unlawful in the place in which it's provided, there remains an interest of that state in obtaining information either from regulated entities or otherwise. And this is how other state law protections may come into play in terms of states where healthcare was provided for somebody coming out of state. But that's where those protections come in and are most meaningful in terms of interstate transfers of information in response to process.
Chuck and Stephen, you're both kind of speaking to some of the limitations of the final rule. I'm wondering if there are any other limitations that the three of you would like to raise in the time we have left here.
Well, I will just mention, I think maybe Joanna, do you have your finger on the button there? Do you want to jump in?
Yeah, sure. So I think one of the main limitations of this rule is it doesn't increase necessarily access to these types of services. It may make patients feel more comfortable going to see their providers, as it should, knowing that their records are going to be safe and secure from punitive non-healthcare purposes. However, it doesn't pragmatically expand access to these services. Abortion is still banned in 14 states, gestationally age restricted in 8 more states. We see new bans. Florida just implemented theirs last week. So, access is still going to be an issue, especially for more marginalized communities who have fewer resources and the ability to travel to states where this healthcare and these healthcare services might be legal.
That's a great point, Joanna. I'll add that, I think another limiting factor about the rule, as I mentioned already, is, that it applies to lawful reproductive care, which can be ambiguous, but it does not protect, for example, it does not protect individuals against criminalization of substance use, for example, during pregnancy. Law enforcement are not limited by this rule in seeking reproductive health related protected health information if they are intent on criminalizing somebody for substance use during pregnancy, for example.
Chuck, anything you wanted to add there, or we can, nope, okay. Sounds good. Another question that has come in is about public health departments that are HIPAA hybrid entities, where some portions might not be designated as HIPAA covered. How do these changes to the final rule might relate to those entities within the health department? And could those entities be required to disclose reproductive health data?
So that's an interesting question. And just for everybody's benefit, so hybrids are, HIPAA recognizes that you have some organizations that are complicated, particularly in the context of a health department, for example. It's a very good example where you may have parts that would be subject to HIPAA as covered entities if they were separate legal entities. And so HIPAA allows those types of entities to carve off those pieces and firewall them so that they have to those parts have to comply with HIPAA, and other parts of the organization then are freed up. But you basically draw these firewalls that requires you then to treat other parts of the organization as though they were other organizations when it comes to data requests. So here, you know, I think like in terms of compliance responsibilities for health departments that are covered entities, I think it's going to be the same as before, to the extent that you're going to need policies and procedures, and you're going to need to review your policies and procedures, whether you're a hybrid or whether your whole health department is a covered entity. You're going to need to review those policies and procedures to update them with this new rule. In addition, you know, you're going to have to factor this into training for your healthcare components. Those are the parts within a hybrid that are subject to HIPAA. You're going to have to update your training on these new policies and procedures. There is discussion of that in the preamble to the new rule, and the HHS is of the mind that because of the length of the compliance period here, which is essentially 240 days from its publication, that will give folks a chance to just include it in their annual HIPAA training. But then I think also like with business associate agreements, which is a responsibility of the entire covered entity as opposed to just the healthcare components, I think it is also a time to review those business associate agreements and just think about, is there anything in here that needs to be changed because of the new rule? Are there some flow downs that we need to include in here for a business associate so that they comply with this new rule? Now, business associate agreements already have to have a provision in there that prohibits the business associate from using or disclosing protected health information in a way that would be prohibited by the covered entity because of the privacy rule. So that may be sufficient here to, you know, make sure that the business associate does not run afoul of this new final rule. But I think that's another compliance responsibility that hybrids and non-hybrids will have to think about as well.
Thanks, Stephen. Just giving a little time in case anyone else wanted to jump in, but turning to public health surveillance purposes, a question is this final rule likely to result in public health authorities in states where reproductive health care has been severely restricted to be unable to obtain pregnancy status information or other reproductive health data for legitimate public health surveillance purposes?
As I mentioned in the discussion and the coverage of the commentary from the rule, generally the language is trying to essentially to reassure on public health surveillance and really maintaining existing flows. Really, I think the answer comes back to the question of purpose is really the lodestar of figuring out whether or not the particular data flow you know, comes into question as a result of the new rule. If you know, certainly longstanding data flows, and it's specifically discussed in the rule of including for reproductive health care, you know, are expected to continue so long as they have a bona fide public health purpose. It's that pivot into the individual enforcement and really punitive use of the data resulting from that collection, and where that's apparent to the regulated entity receiving the request. That's where you know, certainly the rule is strongly nudging to responding entities to consider whether that is a reasonable approach to treat that as a public health request rather than as something that should come in through an alternative mechanism under the statute, which might include law enforcement or judicial process in a state which has, you know, declared certain practices unlawful. But that's not public health. That's something else under the rule.
Yeah, I totally agree with you, Chuck. I think, one of these kind of unintended consequences, like, could be like, what is the impact on public health requests? I think, there's lots of talk about kind of your run-of-the-mill public health reporting and, reporting of deaths or communicable diseases. But, there are other public health activities, as we know, that happen that, public health investigations that are more on the fly and, require access in a short period of time to different protected health information you might have, for example, like a syphilis outbreak or something where there's a need to exert your public health authority to access protected health information. It's a little concerning that HHS is now saying that the covered entities will have to scrutinize requests from public health to make sure, particularly in these states that you describe, that are adverse to reproductive health rights, that, what does that scrutiny mean then for public health? Like, will that mean slowing down workflows around access to protected health information? Will it mean more scrutiny around what's minimum necessary and what is not minimum necessary, which, public health officials can make representations about, and a covered entity can rely on the representations of a public official as to what is the minimum necessary under 164.514. So, that kind of begs the question then, is there going to be more scrutiny now about like what's minimum necessary? Are covered entities going to be less inclined to rely on the representations of a public health official as to what is the minimum necessary? So I guess we will have to see. And I look forward to hearing some feedback from the health departments too, if folks have thoughts about how this has impacted their health departments or how they envision this impacting their health departments.
And I would just add in that it's certainly conceivable that as entities renew data use agreements with public health authorities, that this topic could look at, the possibility of seeking added assurance, not just clarity in the way that Stephen mentioned, but also just assurances of the public health purpose that would come up as with new or renewed agreements. That in other words, there would be other ways of showing the reasonableness of the approach to ensuring the public health purpose.
We're nearing the end of time, so I just want to open it up to the panelists if there are any final thoughts you wanted to share today or final takeaways to share with the group.
Well, it's been eaten away at my brain since my slides that I want to make sure that I emphasize when I talk about the presumption that care is lawful. And I think Chuck hit on this, but that presumption that we've been talking about applies when the reproductive health care is provided by somebody other than the covered entity that receives the request. So in that situation, that presumption applies and the responsibility is on the requester to overcome that presumption. When the covered entity itself has provided the reproductive health care, then that presumption does not apply, and there is an obligation on the covered entity to make a determination as to whether the care is lawful or not, which would impact whether the prohibition applies or not.
And I would just say for all the, obviously there are dozens of questions that we didn't answer. We're certainly interested as we look through these to figure out other future discussions in particular topic areas. Some are very much focused on the clinical environment, some more in public health. So there's certainly a lot more to be discussed as people go through the rule and think it through in the context of the fact patterns of their own compliance with the final rule effective in December this year.
I'm just going to say, if anyone missed any part of my presentation and would like to reach out to me with some questions, feel free. But otherwise, I know this is really about the new HIPAA rule, and we're excited to dig into it more and come back to you all with even more webinars on this topic. So back to you, Susan.
Thank you all. And yes, thank you to everyone who's submitted questions and comments in the chat. We will be saving all of these and, seeing how we can best continue to support all the work that you are doing. Please feel free to email us and get in touch and check out the summit in the fall. We would love to see some of you there. So back to Daniel.
Yeah, so just some closing information for you all. I saw a lot of people in the chat asking about a recording and the slides. A link will be emailed to you in about a couple of days or so. I'd say probably early next week. And that'll have a link to both the recording as well as the slides that will be posted on the network's website, as well as if you did apply for CLE credits, you will be receiving an email contacting you about that from ASLME. But with that, I just want to thank everyone and our presenters and moderator for our time today and wish you all a good afternoon. Thank you all.
Thank you.